Hello, my name is Stephen Spiewak. I'm a wills and trust attorney in the greater St. Louis area with Estate Plan Strategies LLC, where for more than 25 years we've worked with our clients to give them the peace of mind that what they accumulate in life won't be lost to the government, and that what they have they'll be able to pass on to whom they want and the way they want to do it. Today I want to talk to you about how do we treat children fairly when it comes to wills and trusts in the St. Louis area. As a wills and trust lawyer, I've seen just about every circumstance when it comes to the death of a parent. Some children treat estate and trust administration gracefully and with dignity. Others resort to squabbling and pettiness. So it's a concern of many of our clients that they be able to treat their children fairly and minimize conflict and strife when it comes to preparing their wills and trusts. For example, do each child receive exactly the same thing? Or what if one child receives the house and another child receives an equal amount of cash, but the value of the house goes down? So in determining how to fairly split assets between children, sometimes it's a good idea for you to just think about your parenting experience. You've told all of your children that you love them equally, but that you love them in different ways. That's because as your children have grown up, they've each developed different personalities, different strengths, and different weaknesses. And sometimes it's important to take into consideration all of these factors in determining how to equitably divide assets between children. For example, you may have one child who's very responsible financially and has a great work ethic and lives debt-free. You may feel that this child doesn't need as much as his sibling who is struggling financially. Or on the other hand, you may feel that this child deserves to receive more of an inheritance than his sibling who's racked up in debt and has a spouse who will mismanage the funds. So another way to make inheritances equitable between children is also to determine the method in which it's distributed out to them. For example, you may have one child who's prepared to receive a lump sum of money and to invest it or use it for other things. But you may have another child who's likely to squander any lump sum left to him or her due to irresponsibility or addiction, and would be much better served with a trust that would pay out a monthly stipend, or that might have a trustee that would determine what amounts of his or her inheritance should be spent and for what purpose. Another area in which decisions have to be made is who's going to be the executor or the trustee. It's common for parents to name children to serve in these roles, but it's also important for parents to evaluate the qualities of their children to determine who would best serve in that role. For example, who is most likely to treat everyone fairly? Who has the fortitude to stand up to others to make sure that your wishes are going to be fulfilled? Who has good financial responsibility and follow through? All of these things are important in determining the right child to fulfill that role. When you work with your estate planning attorney, he or she will help you to mold a plan that fits the unique circumstances of your family. If you're ready to get started with this process, or you have questions about how to treat your children fairly, please call our law firm at area code 314-542-2210 and asked to schedule a legacy planning session with the mention of this video. The choice of a lawyer is an important decision and should not be based solely upon advertisements.